So, once again, so Manu was unable to join us because of the weather in the Northeast. So he's joining us. He's been kind enough to join us by Skype. He's a professor of history at Hunter College and the Graduate Center at City University of New York. Our discussant is Paula Newberg, a clinical professor and Wilson Chair Fellow in Pakistan Studies here at the University of Texas, one of our colleagues. So thank you both very much for being willing to do this. The format has been 10 minutes for you, Manu, 10 minutes for Paula, and then a round from the Greek chorus, and then we go to the audience. So why don't we get started? Take it away, Manu.
Okay, well, thank you, and good afternoon, everybody. Let me quickly begin by thanking Dan and Zach for inviting my participation this afternoon in this excellent conference. And my apologies to them and to all of you and to Billy, who they did an exceptional job of putting all this together, and the weather and a variety of other smaller things wreak havoc with all of that, and I'm very disappointed that I wasn't able to come. I'm a graduate of the University of Texas, and so this was supposed to be a bit of a homecoming, but I'm going to do this virtually, and I hope this works. Okay, so I've circulated a paper called K.M. Munshi and the Origins of Fundamental Rights in the Indian Constitution. The paper essentially makes 5 points that I'm going to summarize very quickly. I'm sorry, there's a bit of a feedback loop in this. There's an echo in my ear. Can you hear me okay on your side?
Yeah, we can hear you fine.
Okay.
All right, try that. Is that better?
Okay. I think so, yes. Okay, so the person who is at the center of my paper is a man named K.M. Munshi, who was a constitutional lawyer and activist throughout the 20th century. He was an anti-colonial figure who participated with both sides of the nationalist struggle. So he was friends with and considered himself a member of the extremist nationalist wing and the moderate nationalist wing in South Asian anti-colonial politics. By the teens and 20s, he had grown to become friends with people like Annie Besant and Muhammad Ali Jinnah, and really saw himself as someone who was central to many key developments and arguments in anti-colonial nationalist politics. But he eventually thought that the greatest person on the stage was Mahatma Gandhi, and he eventually latched onto him. He called him the Colossus, and he saw himself as a Gandhian. Even though this was true, Munshi was, from the outset, and then this is something that took on more strident tone over the course of his life, was a majoritarian. He believed in democratic politics, but he believed in majoritarian democratic politics. And this is central to my observations about his role in the creation of the Indian Constitution and of fundamental rights in the Indian Constitution, and their role in inflecting international human rights norms, both bringing them in domestically and then reverberating out into what their implications were in the larger world. To boil Munshi down into a nutshell, in 1928, the Simon Commission talked about what a constitution in India might look like. It didn't involve any people from the subcontinent. This created a backlash, and the British then invited people who might have something to say to come forward. This resulted in the August 1928 Nehru Report, which was something that was supposed to bring together points of view from all sides of the spectrum. The Nehru Report, however, was rejected by the Muslim League and by Munshi's friend Muhammad Ali Jinnah. Because it was rejected, Munshi then, and this is the point of departure, 1928, concludes at that moment that Muslims were developing what he called a quote-unquote master race complex, and therefore he felt that a much more position of defense for the majority community was required. This culminates his new point of view in a confrontation with Gandhi that develops over the course of the 1930s and then eventually results in Munshi's expulsion from the Indian National Congress in the early 1940s. He then subsequently outright embraces Hindu majoritarianism in what's called the Akhand Hindustan Conference and participates in what is outright Hindu nationalist politics in this period, and then is welcomed back into the Congress fold in 1946 by Gandhi himself, where he then takes a prominent role in the Constituent Assembly and especially in the development of fundamental rights in India's constitution. 1946 is the exact same moment that Jawaharlal Nehru becomes the interim Prime Minister of India. Under the Cabinet Mission Plan, a temporary government is put into place to help oversee the transition to a new post-colonial country from the colonial state and for the creation of a new constitution. So this is just a brief parenthetical. This isn't necessarily part of the paper, but it situates the paper in my larger work and my larger arguments. 1946 marks the beginning of the ascendance of what I think is called Nehruvian internationalism, which was premised on the idea of a world of mobile populations moving freely in and between states, protected by global constitutionalism founded on universal human rights. So Nehruvian internationalism is something that explores the relationship of the global and the local, and of the idea of the post-colonial with notions of the universal. And this was actively pushed by a woman named Hansa Mehta, also a Gujarati like Munshi, who served on the Human Rights Commission at the United Nations and also on the Fundamental Rights Subcommittee. And this fact bound up what was going on in the Human Rights Commission with what was going on in the creation of India's constitution, and the rights conversations that were taking place in both situations were interlinked. Now here I just want to flag one thing, which is in my larger work but not in this paper, which is that it is India that plays a very prominent role, in fact I believe the leading role, in splitting the international covenants of human rights into two. It is not, I believe and argue, a product of an American conspiracy, although the United States had its own reasons for splitting the covenant. It was something that India strongly believed in and believed in from the outset, and then pushed that all along, and they played a very dominant role in its eventual splitting into two in the 1950s. So with that in mind, let me just summarize very quickly the three major points about Munshi and the origins of fundamental rights in the paper. Essentially, what I'm arguing is that Munshi was a majoritarian. And because he was a majoritarian, he saw the idea of fundamental rights as something linked to a certain notion of majoritarian democratic politics. This is manifested in three ways in which he tried to inject majoritarianism into the constitution-making process and into the ideas of rights that it was supposed to then create. In 1934, Munshi created a constitutional note that Gandhi personally read, approved of directly, and then was eventually published, and this served as the foundation for a lot of future conversations. In this note, Munshi argued that there had to be proportional representation in order to create a legitimate constituent assembly in a post-colonial country such as India. The Cabinet Mission Plan in 1946, however, rejected this concept altogether, instead going with existing legislative assemblies. But because the Muslim League decided to stay out of the Constituent Assembly, this made this particular issue less important. So Munshi pivoted and then focused on two key issues. The first had to do with the notion of justiciability. He argued that when they were considering fundamental rights and what kinds of fundamental rights to put into, to enumerate and to put into the Indian Constitution, that only one type, the justiciable type, the type which could be brought before a court, should be allowed, should be enumerated and allowed in the Constitution. Justiciable rights coincided with political and civil liberties, as opposed to an alternate conception of rights, which had to do with economic, social, and cultural norms. Munshi rejected economic, social, and cultural norms as being equal to the justiciable kind. His argument was that he believed in parliamentary sovereignty. That is, that the parliament had to be sovereign and that it had to be free to pursue whatever kinds of laws it wanted pursuant to justiciable fundamental rights. So he saw that there should be, he argued then that there should be no real restraint on parliament. This argument was lost as other people from the Fundamental Rights Subcommittee argued that there should be two types of rights, one justiciable and one non-justiciable, that they belonged in separate parts of the Indian Constitution, but that they were both equal and that they were both fundamental and that they both should be treated as such in the practice of law thereafter. So Munshi again pivoted when this idea failed, and he now tried to advance what was called a due process clause, which is similar to due process clauses in other international constitutions, particularly like the ones found in the United States. The due process clause was eventually rejected in the Indian Constitution in favor of a procedural clause based on one found in the new Japanese Constitution emerging out of the Second World War. The issue was a difference between notions of procedural due process and substantive due process. Now, substantive due process is something that helped to perpetuate and defend a certain kind of rights. Political and civil liberties often could be defended adequately and, in fact, maybe even substantially through substantive due process. But as the Indian Constitution was being developed, Justice Felix Frankfurter of the U.S. Supreme Court gave an opinion to the Indians which suggested that due process was a problem, particularly in the application of the New Deal. And so this might hamper efforts at social progress. This led to a very sort of complex debate, which I have a little bit of in the paper, but I can't really get into here. I'd be happy to talk a little bit more about this in any discussion that might follow. But short of it is that the substantive due process element was rejected. Now, Munshi's reason for latching on to substantive due process was not just that he was an ardent defender of civil and political liberties, but rather that he believed that economic, social, and cultural rights were tools by which the majority could be sublimated to the will of the minority, and that therefore these were very dangerous tools to empower the state with and had to be curtailed or rejected in favor of a privileged form of civil and political liberties. This is made clear ultimately in his in notes that he writes several years later, where he lambasts the notion of religious freedom as it appears in the Indian Constitution, because he believes that that protects the liberties of minorities at the expense of the majority community. And it's there that his whole argument about privileging civil and political liberties at the cost of anything else unravels. So let me just make some a concluding remark, and then thank you for your time and your attention, and then turn it over to Professor Newberg, and I look forward to hearing what she has to say. So all three of Munshi's major attempts to insert majoritarianism into the constitution-making process and in the resultant constitution as well were rejected. Munshi remained proud of the democratic state that emerged, but his resentment at leftist ascendants and his overall bitterness with India's direction grew ever more palpable. Over the 1950s, as the head of a cultural institution called the Bharatiya Vidya Bhavan, the preeminent cultural institution in the country, Munshi turned from the world of policymaking and the law to that of culture to make his mark, and his efforts culminated in the effort to rebuild a famous temple in the West, which resonated with the Hindu nationalist movement. By the 1960s, Munshi's work is completely infused with anger and posturing, meant to recast himself as a forlorn Cassandra, wise but unheeded and frustrated by his own marginality. And so the last point I just want to make here, though, is that Munshi's majoritarian vision for India's constituent assembly and resultant constitution was for the most part rejected, as exemplified by this triple loss that he suffered. But the questions that came up during the due process debate and the positions that various assembly members took made clear the complexity of nearly every question. Essentially, I end by asking whether India is facing a crisis of civil and political liberties today, and whether Munshi, even though Munshi's The reasons for advocating some of the positions he did, I think, stem from a majoritarian perspective and should have been rejected rightly at that time. Whether some of his warnings nonetheless have implications that some of the more progressive partners at that time might also have had serious concerns with. So I'll leave it on that point. Thank you very much for your time and attention, and I look forward to hearing again what Professor Newberg and the Greek course have to say. Thank you.
Great. Thank you, Manu. Thanks.
Well, for those of you who haven't had a chance to read Manu's paper, I definitely encourage it. It's a really lovely piece of historical analysis that highlights a great deal of what has happened since in India. So what I'm going to do very quickly is try to take off from where he ends. He ends sort of provocatively saying you don't want to draw a direct line from all of these debates in the 30s and 40s to the crises of India today. But I actually think maybe you can if you look at jurisprudence in certain slightly contorted ways. So what I'm going to do is look at two cases which come out of something that was embedded in Manu's paper, and that was a discussion of the relationship between fundamental rights on the one hand and directives of state policy in another. It's a problem that exists in a lot of post-British colonial states and remains a real interesting problem in India and Pakistan today. So the directives of state policy in the Indian Constitution are supposed to be fundamental to the governance of the country. And in incorporating them as well as fundamental rights, the Constitution itself set up a tension not only between policy and rights, but between means and ends. And these have been arbitrated over and again in the Indian courts, notably by two cases that arose in the late 60s and the early 1970s, one called Golak Nath's case, the other Kesavanandan's Bharati's case. Both involve property and land tenure, so this is for Karen. And had a great deal to do as well with the fact that the Indian Constitution had made very specific recommendations about the change in land tenure. So Golak Nath's case concluded that Parliament could not abridge fundamental rights, and that the fundamental rights portion of the Constitution was part of what it deemed the basic structure of the Constitution. But the courts decided that not the Parliament, but the courts themselves would decide what the scope of rights would be. So contests about rights and policies became a dispute about the separation of powers, and the court then took the side of fundamental rights. A few years later, in Kesavanandan's case, it essentially reversed Golak Nath and said, or so it seemed to say, that the directives of state policy were in fact compatible with the fundamental rights sections of the Constitution. And the court tried to underscore the progressive policy by retaining the right to oversee Parliament's interpretation of the structure. The courts would decide what the rights were, what the basic structure was, and when constitutional amendments would be enforced, using very general terms like republicanism, federalism, and democracy. So they took a kind of pre-constitutional notion about policy as permission to change, but only with court oversight. Now, it should be noted that there were 13 judges and, by everybody's account, about 65 different opinions within this one judgment. No set of scholars has agreed as to exactly what it said at any one time. I think the biggest issue that came out of it was very well expressed by Upendra Bakshi a few years later, who said that the truth is that all the fundamental rights, together with the majority of the directive principles, elucidate the constitutional conceptions of social justice for India, values which cannot be fulfilled concurrently in an economy of scarcity. So they were trying really to link this to the problem of India at that time and to this day. I would add actually also to an economy based upon a particular version of national security, which meant that the presumption of the directives of state policy, that the state could decide what it was going to do when it wished to have them in accordance with rights, left India to be at odds with the United Nations, the international human rights community, and a great deal of international law regarding a number of decisions it took under the basis of state directive in its borderlands, in questions about economic rights, and so forth. So the only moment at which this began to coalesce was with the development of the Indian National Human Rights Commission, which then took to overturn laws that neither the courts nor the Parliament were ready to overturn, like the Terrorist and Disruptive Activities Act that had hundreds of thousands of people in jail without trial or even charge. So this kind of creates one kind of model in this context for how the majoritarian question works. It's important to remember, though, that the question of who was a majority and who was a citizen of anything lay at the heart of the partition of India and Pakistan in any case. So in Pakistan, this has taken on a slightly different route, and that is Pakistan has no directives of state policy in its constitution. But since 1949, it's had something called an objectives resolution, which may or may not be justiciable depending upon the moment that a court decides to read it. And I'll leave Tayyab to remember all the rest of the citations here. But some jurists have led the objectives resolution to be a Grundnorm, and that's caused enormous difficulties in its jurisprudence. And the resolution itself almost has language that would be like a directives of state policy, but in a different way, because it holds that sovereignty over the entire universe belongs to Allah alone. Principles of democracy, freedom, equality, tolerance, and social justice, as enunciated by Islam, shall be fully observable, wherein Muslims shall be enabled to live their lives in accordance with the teachings and requirements of Islam, as set out in the Holy Quran and Sunnah. For those of you who don't normally traffic in this language, there's not a single word that is not essentially contestable. And that meant that you had a guiding document that gave no one any direction for guidance. So who has rights, what the role of Islam is, the status of non-Muslims under law and so forth have been covered by radically divergent views of the content and status of the resolution, and therefore of every Pakistan constitution. Unlike India, Pakistan has had several, and large periods when there was no constitutional rule at all. So Pakistan's courts began to cite the Indian cases, particularly Goloknath and then Kesavananda Bharati, to support the idea of state policy, even without sanction. And this was particularly convenient at the frequent moments at which it encountered authoritarianism. And this was how Pakistan has dealt with questions of fundamental rights. In other words, ignoring the fundamental rights part of its constitution and then finding ways to kind of make them malleable. So it became kind of a metaphor for addressing issues of executive power, representation and democracy, and the connection between religion and rights. It also, as it did in India, acted as an excuse for determining when you could and could not have judicial review. And so all of this, in a way, is to say that Munshi's concerns in the 30s and 40s echo today in virtually every Pakistan court judgment and the occasional parliamentary debate, which doesn't happen all that often. Even more, the status of the objectives resolution is really now at the heart of negotiations that may or may not take place between the government of Pakistan and the Pakistan Taliban, which says they don't have to actually agree to negotiations under the Pakistan Constitution because every government has violated the Constitution by not installing Sharia law under the objectives resolution. So whereas in India you have conflicts about this that have occurred in everywhere from Assam and the northeast to Kashmir and now Telangana and the previous times in Punjab, in Pakistan you have this across the country with regard to how indeed you can enforce a kind of rights-based jurisprudence, but with regard to the objectives resolution. So there are different kinds of debates. They all involve both economy and security, and more to the point, take on the fundamental issue that was raised by Munshi in a certain way, which was who is a citizen and what is the relationship between the citizenry and the government.
Great. So, thank you, Paula. So we'll turn next to the Greek chorus.
Hi, this is James Melton. So I have less of a question or challenge and more of just a general observation. And we've talked a lot so far today about things like the diffusion of constitutional rights and borrowing and sometimes literally copying from one constitution to the next. And what I think is interesting here is how the debate during the drafting of the Constitution, even before in India, has shaped the rights that are in the Constitution, shaped their jurisprudence, and has really localized those rights. And I think that that's fairly interesting when we've been talking all day about this borrowing, and that it, in some ways, assumes that debate isn't present, right? And so I just think that's fairly interesting. And in some ways, I think that lends efficacy to those rights that maybe wouldn't be there without that sort of dialogue. So I think that's really interesting.
Hi, this is Paola Vergallo from Argentina. Sorry for my ignorance, but I wanted to ask you, whether the history of the agreement about justiciability on the first generation right in India is connected or not to the agreement and the history of the Western world. So whether there is a different justification for the justiciability of those rights.
My comment is more a question whether you think that the essential features, basic structure, test fashioned by the Indian courts, is that you feel, or Munshi would feel, a good response to the dilemma between parliamentary system, parliamentary sovereignty, and a written constitution? Is that a adequate balancing device?
Hi, my name is Courtney Young. So I'm wondering if separation of powers was the reason or the only reason that India had for pushing the distinction among rights in the UDHR that you talked about. You said that India was pushing that distinction, and then you mentioned later Munshi's concerns about economic and social rights versus civil and political. And I'm wondering if that was the same, if there was the same logic going on, or if there were other concerns.
Hi, I'm Juliet Elementary. I really have nothing to say except that I learned a lot and thought it was fascinating.
Hi, I'm Kiyo Tsutsui. 2 questions. One is about broader implications of this particular case. What lessons should contemporary constitutional writers take away from the case that you present in this paper? The second question is very specific. You mentioned in your presentation, and you mentioned on page 11, that the new language that was adopted came from the new constitution of 1946 Constitution of Japan. How did that happen? Is it American constitutional writers going to India and advising them, or how is a connection between Japanese and Indian political elites that were established before World War II? What mechanism led to the adoption of this particular clause?
Okay, so normally we would go to the audience. So we'll pick up a couple of questions from the audience if there are any, and otherwise we'll go back to Manu. Okay. Can you hear me?
Yes.
I was wondering if you could just explain a little further, give some more context on the disagreement regarding perceived rights and law and content of them. And so I'm in disagreement with Munshi on whether justiciable rights will be protected from violence.
And unless somebody else has a question, I have a question of my own. I'm really interested in this. One of the goals that I had in this conference was to explore the different kinds of political aspirations that are sometimes captured by the language of rights. And this is our first nationalistic, majoritarian, right-wing, conservative version of fundamental rights that I've seen. And so I wonder how you turn, how someone with the sort of majoritarian nationalistic kind of agenda turns to fundamental rights. There seems to be a tension that I wasn't fully able to resolve reading your paper. I guess, in other words, how does, I don't know, even due process turn into majoritarianism at some level? Why is it a way to push back against minority rights? All right, so your turn.
Okay, great. All right. Thank you, everybody. I had a little bit of trouble hearing some people. I do want to very quickly, just because I didn't get a chance to, just shout out to Taya, Manu, an old friend. Hello, nice to see you. Thank you for your question. Okay, so where to begin here? All right, let me just start with the last question first on types of rights. So I think that you put your finger on a really important I think, strand of my argument, which is that rights in and of themselves can belong to people of all different parts of a political spectrum, and that they themselves aren't necessarily inherently conservative or progressive or anything else. And even as they're administered, might have multiple kinds of ramifications that aren't necessarily fully thought through. So the point in this is that a person like Cam Munshi is looking at a set of ways to promote his particular view of things. The idea of due process is essentially that once he loses the debate on whether or not to have economic, social, and cultural rights, i.e. what go into the directive principles, once he loses that, and once they are there and they are supposedly equal to the justiciable civil and political liberties, it means that the government is now empowered and mandated to protect cultural rights and norms, or group rights. And this, in turn, would mean that potentially a group such as a minority community, like is the thing he was most concerned about, a Muslim community, could petition the state for a series of protections or things that they were due in terms of material resources. He feared this above all else. So due process, in this case substantive due process, was meant to challenge any laws that the Parliament might then enact that would be pursuant to the directive principles and trying to implement them in a particular way that might negatively impact, in his view, the zero-sum being, if you delivered things to minorities, you're going to be taking things away from the majority. So I think that's the overarching view. Now, two people asked, if I understood correctly, about Hansa Mehta and the splitting that occurred. I think someone used separation of powers, but the separation of the types of rights. So first, to clarify, this can occur in the UDHR. It's not the Universal Declaration of Human Rights. It's in the international covenants on civil and political rights and on social and cultural rights. That occurs in the 1950s. Those are the documents that serve as the basis of law, international law, from the point at which they're ratified forward. So the context of this, which is not in this paper, is the Cold War. And India plays a significant role, not just in this thing called non-alignment, which everyone talks about, but in a more complicated activist foreign policy, which the grand strategy is something which they called then, and I talk about, called One World, a one world foreign policy, and that essentially argued that the world had different strengths, different communities of the world had different strengths, and we had to latch onto those strengths, and we had to accept the principle of difference. That is, one of the things that Nehru and Hansa Mehta and Indians were critical of in this period of the 40s and the 50s and the founding of the concept of rights is the violence of homogenization in the universalization of rights. And so, because they were particularly sensitive to the idea of violence, because of the legacy of Gandhi, and for Nehru this is an implementation of a non-violent foreign policy in the interest of the creation of an ethical state, the argument is that difference had to be acknowledged and then embedded into the principle of rights. And the only way to do that, they thought, was to separate two genealogies of rights, two types of rights, justiciable and non-justiciable, into two separate but equal covenants that would be in conversation with one another, acknowledging the different strands of background on which they're based, and then placing them into conversation with one another so that this difference was always something that had to be seen and put forward, acknowledged, but then also dealt with in a respectful manner. So that's that part. There was a question I heard about why Japan. So there's a longer history answer to that, which is there's a particular reason for Japan that was long seen throughout the 20th century as a non-Western modern. And the historian Jamil Hayden has an excellent book called The Politics of Anti-Westernism in Asia that thinks up the place of Japan, particularly beginning in the early 20th century, about the Russo-Japanese War, and the place that takes in the Asian/non-Western imagination and why Japan has a particular role. But that isn't necessarily what's going on here. There are two parts. One is that as the constitution-making process gets underway in the 40s, India sends emissaries around the world to look at international constitutions and to bring them back into the debates and to talk about the strengths of different constitutions and the weaknesses of what India might fruitfully bring in to the conversation. Japan, in particular, has a place here also because in the Tokyo trials, a prominent Indian figure named Bhagavan winds up serving on the Tokyo trials. He's one of the only people who actually rejects the Western argument and essentially defends Japan in what's the Asian equivalent of the Newberg trials. And so Japan has a particular place in the imagination of the post-war order and in terms of a notion of a universalizing kind of justice. I think I'm missing a couple of things here. Right. The very first question was about localizing, this process of localizing and the justification of rights. So in South Asian history and the history of modern India as a nation state, one of the criticisms, and this is something that one might see, for example, in the work of Perry Anderson, whose work was just, he had a 3-part series in the London Review of Books, and he's turned that into a book too. In that work, the argument is that the Indian Constitution is essentially derivative. It stems from the 1935 British-created Government of India Act, and that basically all of the principles that served as the foundation for the constitutional foundation for the Indian state stem from this, and that they were taken whole and that they mean the same thing. And so I don't think that that's right. I think that what my paper shows, but also what a whole number of people currently working on this topic, I think we're all in agreement. This includes a Harvard graduate student named Madhav Khosla, for example, or the new Yale historian Rohit Dey. There's a number of people, I think, who are part of an innovative set of younger people also coming to these kinds of conclusions. I'm just sort of an interloper in this larger crowd, but I agree with them that each and every single idea was discussed. And something even as straightforward, it's something that might be very straightforward, like a particular kind of freedom, like freedom of religion, was debated, talked about, looked at from multiple angles, and sometimes invested with really new local meanings. So what I understand this conference is talking about, and one of the reasons I'm especially regretful that I'm not there, is how are universal international norms domesticated? And I think that what this touches on is the fact that what you're really talking about is a series of transnational flows in which it isn't necessarily about the local becoming global or the global becoming local, but a dialectic process by which these things are constantly forming and transforming one another, so that the local is informing something at the global level, and the global is informing something at the local level, and multiple locals are in conversation with one another. So it's not necessarily even that the local goes global and then the global comes back to another local, but different locals are informing each other, and that these in turn are breaking boundaries and sovereignty, principles of sovereignty, and extending the concept of what it means to talk about something transnationally or internationally as well. So I think there are all of these different kinds of issues which are wrapped up in what I'm talking about, and presumably what all of you are spending the full day talking about. So I'm afraid there were two questions, one of which was Thayyab's. I just couldn't hear properly, so I apologize. I couldn't hear exactly what the question was. Something about mechanisms, but I'm going to have to pass because I couldn't hear them. Just one last point about Professor Newberg's comments. I just wanted to clarify when she talked about a national security state, and if I couldn't hear everything totally, but as best as I can hear it. And then talked about certain pieces from the 1960s and 70s and the way that this draws some lines from what I'm talking about through the present. The only distinction I would make here is, well, I think it might be a substantial one, which is that, as I see it, the foundation of what emerges as the national security state of India does not really occur until 1963. That is after India loses the Sino-Indian War, and a lot of what had gone on in the 40s and 50s, and this internationalist vision, which is frankly about breaking down notions of national sovereignty and creating, again, to be frank, a world government in the United Nations founded on principles of human rights. When all of this sort of falls through, and when Nehru's vision is shattered, he says then that they were living in a world of illusion. That's when notions of sovereignty, territorial integrity, and national sovereignty are then backdated into the Constitution. And they appear all over from that point forward. And then India adopts a very muscular foreign policy. They begin to reject the United Nations immediately thereafter. They are much more arrogant, and they adopt a much more muscular posture towards things like Kashmir and the marginal states. The states on their territorial margin in terms of incorporationist and majoritarian rhetoric. All of these things increase from this point forward. And it's a long slope down as India then essentially vacates everything it's done for international human rights norms over the 40s and 50s. It hollows out that work and then creates a gap between its moral posturing and its positions, which is why I think that Professor Newberg's critique is absolutely correct. I'm just positioning it as a result of a particular historical moment in the late, early 1960s. So I hope that addressed everyone's concerns. I'm happy to answer any more questions if there are, but thank you again for this opportunity.
Great. Thank you very much. That was a nice ending, kind of wrapping up a bunch of themes together. So thank you very much, Manu, for joining us for this. We are really sorry that you couldn't be here for the more extended conversation that we're having. I found it really interesting. I'm sure you would have too. So again, thanks for joining us. I'm sorry you couldn't make it, and we'll see you the next time maybe.
Thank you.
Bye-bye.